Hello, my name is Len. I'm the host of Targeted Justice v. Garland, a podcast about an extraordinary lawsuit. People ask me, what's your North Star? What is your moral compass? To me, my North Star is a woman, her name is Anna Toledo, who declared on many occasions that liberation of targeted individuals worldwide is her utmost priority and the purpose that she goes to sleep with and wakes up with. On many occasions, Anna has been a target of misguided criticism, but not a target of constructive criticism. And that's sad. And I hope that you, our viewers, understand the difference. To me personally, I've never seen a person so fully and genuinely dedicated to the mission, so sincerely engulfed in the battle, applying all her intellect, including her emotional intellect and intuition. Please say hello to our viewers, Anatolia.
Thank you, Len. Thank you for such beautiful words. Every Sunday you outdo yourself, so I am so embarrassed, and humbly, and graciously accept them. Thank you so much. Happy to be here.
Wonderful. This word come to me so easy because I don't have to make it up. I just tell our viewers what I think. Today's legal update contains something very special. I call it the new level of honesty, the moment of clarity. I compare it to the moment when we say out loud, the emperor has no clothes. We owe this moment of clarity to the filing by Anna Toledo that I consider a culmination of our journey that started back in January of 2023 when we filed it in the federal court for the District of Victoria in Texas. And today, at the end of this year, in December of 2023, we pushed the defendants to the point at which they can no longer defend themselves unless they deceit the court, the plaintiffs, and the general public. All traps and tricks have been exhausted, and what's left is the emperor has no clothes. This is the moment of clarity. This is the reply brief of plaintiffs' appellants filed December 8th, 2023. I want to give you an updated timeline. On September 5th, we filed an opening brief. On November 6th, the defendants' appellees filed a legal brief. That's the government defendants. Then we drew attention of the court that that legal brief wasn't really compliant. And there were 17 things that Anna produced in her motion to strike, which was denied, and then motion to reconsider was also denied. And then finally, December 8th, docket number 62, this is the legal brief. This is the moment of truth. This is what we're going to be talking about today. Anna, did I miss anything?
Yeah, I have to clarify that I filed it on the 4th. And yesterday I got a notice that the caption of the case had like contained it was not identical to the one they approved. So I resubmitted it on the 8th with the correction that they requested. Okay. I had tried to make it accurate, like Cable, since he's no longer the director of the terrorist screening center. I put in there former director, but since that has not been approved from the court, they returned it. So it was in reality filed on the 4th, which was the deadline, and the December 8th filing, if the court deems correct, is retroactively filed as if it had been filed on the 4th. But it's the same content. The only thing that changed is that the caption, they said that it was not the one that they had approved of. So I copied it again, even though it contains that mistake, because Cable is no longer the director of the terrorist screening center.
But going forward, what are we going to be referring to docket number 61?
It's the same thing. So I'm not sure how, if the court will just Eliminate 62 and put it as 61.
So either 61 or 62, they're identical, only with one change. Okay, fair enough.
Yes.
All right. And this is the document that opens up with fireworks. Summary of the arguments. You presented very clearly that the defendant's unconstitutional policy of permanently placing unsuspecting Americans, including toddlers and grandmothers, on the terrorist screen database, devoid of the legally required reasonable suspicion criteria, stigmatizes and harms innocent people that have never been arrested, indicted, tried, sentenced, or convicted of any terrorist offense. And then in the very next sentence, you say the arguments of the defendants are based on deceit. I think that simple sentence really put things in the right perspective for me. This is why I call this document, when we actually face the dragon, we actually go and say the emperor has no clothes. With the arguments of the defendants are based on deceit. You cannot be any more clear. I guess you could have been, but your profession would not allow you to. Am I correct in this assessment?
Yeah, well, I took that intentional deceit is a phrase that the Fifth Circuit used. I don't know if you recall, in a case that we discussed a few weeks ago, where the defendants refused to give the jurisdictional discovery that the plaintiffs needed, just like in this case. So that's why I chose that word, because it's a court-endorsed word to use, the intentional deceit. Now, the deceit here is twofold. First of all, they're saying that plaintiffs did not plausibly allege that they were on the TSDB. That's not correct, because as you can recall, in no less than 25, 30, I don't know, occasions in the paragraphs, it says plaintiffs, by information and belief, they allege that they are on the TSDB. But both Calvert and Stewart specifically allege, I have information to believe I am on the TSDB because of this and this and this. So that's number one. It's deceitful to say that plaintiffs did not allege they're on the TSDB. And the second part of it is the deceit that entails hiding the TSDB status information that since April, plaintiffs were asking the court to order defendants to produce. That is, the deceit is hiding the information that corroborates that all of these plaintiffs were illegally placed on the TSDB. So it's a twofold thing, saying they didn't allege it and then hiding the information from plaintiffs.
I actually took the time and went through all of your arguments, so we can take a look at them separately and then again all together. Your first argument is that district court decision was erroneous. And the reason it was erroneous is because it's based on the misleading statements by the defendants. So the defendants entirely disregarded the uncontroverted facts of the pleadings that serve at the crux of plaintiff's claim. The defendants reduced this fact to conspiratorial, far-fetched, facially frivolous, and fantastical. In fact, they're specific and real. The district court disregarded that the FBI is the agency vested with the authority to place individuals on TSDB using secret criteria and distributing this information, which constitutes government defamation. And then you made arguments that TransUnion versus Ramirez is applicable in our case. And they say this case doesn't apply. And I understand that they changed their strategy. On two different occasions, they said it doesn't apply, but what was the first argument and what was the second argument? Because I found it really interesting. Could you elaborate, please?
Yes, the first argument was that the TransUnion case involved they said something like, oh, like the district court said, oh, they stipulated, the plaintiffs there stipulated that they were on the list, and on the OFAC, not the TSDB, but the OFAC list comes from the TSDB. On the OFAC list, it doesn't apply because it's a different context. That's what the court said. It's a different context, that it wasn't, quite honestly, I really don't understand much the logic, but it says it doesn't apply because that had to do with a stipulation that the party stipulated that they were on the list or something or the other. But in this case, defendants are distancing themselves from that clearly erroneous legal conclusion by the district court. And they're saying it doesn't apply because they didn't allege that they're on the TSDB. That's what they're saying now. They changed the tune. They're saying it doesn't apply because because their allegations don't establish that they're alleging that they're on the TSDB. And therefore TransUnion doesn't apply.
Thank you for explaining this. Perhaps the main argument by which district court made their erroneous conclusion is because nowhere the defendants cite any authority in support of the legality of the practice of including on the TSDB or any other criminal database the names of people that do not meet the reasonable suspicion criteria, and instead using secret criteria that has never been authorized by law or regulation. This is very connected to those disappearing sentences that we investigated with the magnifying glass. But you put it together as a part of this argument. Please expand on this.
Well, they don't dare defend the legality of calling an innocent person a suspected terrorist because they know it's not legal, right? And one of the things that I cited repeatedly in this brief is the regulation that we mentioned last week, the regulation that it says you cannot put anybody in any list without reasonable suspicion. And that comes from the Omnibus Crime Act that authorized making of these lists left and right, that they're called projects. And so they have to safeguard people's civil rights and privacy rights. And the chief of the agency that maintains the project has to assure in writing that he's actually doing that. So I would love to see Mr. Christopher Wray's documents assuring that he is protecting the privacy and civil rights of non-terrorists while they're being included in a terrorist list. I'm just dying to see that. Then there is the issue that the regulation says the Attorney General can exempt from the compliance of any of these requirements. That is another thing we need to see. If Attorney General Merrick Garland told the FBI, you don't have to comply with a reasonable suspicion standard, because he needs a clear and compelling evidence and reason to exempt from the compliance of any of these legal requirements. So I think that there's a lot to be discovered, but that's what it boils down to. The practice is illegal, and that's why defendants don't defend it. That's why they don't even argue. They don't touch it with a 10-foot pole. They don't touch with it. Neither did the district court defending this illegal practice.
All right. That was not even addressed anywhere in the defendant's briefs. And you explained perfectly, either you have a reason to distribute it or you have a waiver that you can distribute without any reasonable suspicion. Which path do you take? If they are cornered and if they're asked point blank, these are two poisons, which poison do you take? Do you blame it on Christopher Wray or do you blame it on Merrick Garland? Both are.
And don't forget Bill Barr, because Bill Barr was there before Garland, and our internal information says that the targeting began really, really bad in 2017 when Cable entered as director of the Terrorist Screening Center. Our internal information states that more than 60% of self-reported targeted individuals began to be targeted on or before 2017, when Cable became the director of the Terrorist Screening Center. Most importantly, this regulation does not leave any room, does not mention the possibility of using secret criteria for placing anybody on any criminal list.
You know, what comes to mind is not only Mr. Cable became a director of a terrorist screening center, but Mr. Christopher Wray became the FBI director also in 2017. So they kind of have the same timeline. But Christopher Wray did not resign, but Mr. Cable did.
This is something that a savvy journalist should ask Trump. Are you aware that both the FBI director you appointed and the terrorist screening center director he appointed were promoting the inclusion of innocent Americans in a terrorist database?
From what I'm seeing during the congressional hearing, Christopher Wray does not present any reasonable, logical, meaningful explanation. He's just been decimated by the questions of the Congress people. But let's move on. So the next item was about the question of plaintiff's standing. These are the four arguments made in this regard. The defendants argued that the amended complaint fails to plausibly allege an injury traceable to any government conduct. I just have to comment about that. I just have to
Yeah, you
comment
put
about that.
yourself on the terrorist list, right?
Yes, and we've said it so many times. We said Mr. Lighthouse was waiting for the ambulance, and the sheriff said we need to secure because there's information that there's a terrorist lives there. When they say it's not traceable to any government conduct, where do you think the sheriff got that information from? From American Botanical Society? I don't think so. That's just laughable.
It is. And when you take into consideration, which is one of the issues I bring up, when you take into consideration what Steve Friend is, whistleblower Steve Friend has been hollering everywhere that special agents were being forced to put people to classify them as domestic terrorists. You know who is the source of the conduct that is causing injury to plaintiffs? Yes. It's not the special agents, it's the supervisors forcing the special agents to put in more and more people to classify them as terrorists.
Further, you're right, it is disingenuous for defendants to assert that the district court was correct in concluding that because plaintiffs have not seen the list, they did not plausibly allege that they're on. Cases exist where the court have been allowed to inspect TSDB. And if you allow the discovery, the case goes away. And at the end of the day, the information that they're fighting tooth and nail against disclosing this information is non-classified.
Here's the thing. In the cases where the court has ordered discovery, both, for example, in the El Haiti versus Cable case before Judge Strenga, and in the Kulak v. Gray, in where the court did an in-camera review of the TSDB, both those cases and many others where the attorneys or the court has inspected the TSDB involved Category 2 people. They did not involve innocent people that should not be on the list. So I don't know you, but if I was the court, I'd be really curious to see, wait a minute, I want to see if these non-terrorists are really on that list. Because if they are, this is outrageous and it's illegal. But the court was not curious to ask for that. And that's why for 3 months, our request for limited discovery was disregarded, only to be denied as moot at the end of the case. And that's one of the issues that we brought on appeal, that was a mistake by the district court.
Because the district court went with the arguments by the defendants that were misleading in nature. The next item in the brief is about the jurisdiction over individual type of capacity defendants. And this is straight out of the federal regulations that imposes on the individual capacity defendants the obligation to retain control and supervision of information collection and dissemination for the criminal intelligence system, such as TSDB and NCIS. If we are suing the FBI, the DHS, the DOJ, then we can say that the people at the top of this organization are individual capacity defendants are also involved.
Well, what they're saying is that we have to treat individual capacity defendants, Ray, Mayorkas, Weinstein, Cable, as if they were Len Bear or Ana Toledo, that the court has to have personal jurisdiction over them. But first of all, the Texas statute is a long arm statute that, as long as it's consistent with the process, the long arm statute gives jurisdiction. But more importantly, my argument is, look, these people said to the court, oh, we are the government. Remember on the controversy of the certificate of interested persons? They said, we are the government. Therefore, we don't have to list the interested persons. So one of the things I'm saying to the court is, wait a minute. If they, for one thing, they call themselves government, they cannot then come here and say, oh, no, we're not the government. We're individual capacity defendants, because it would be a double standard thing. And the other thing is that they carry out the policy of the agencies that translate to including innocent people on the TSEB. If it wasn't for Christopher Wray's policy, adoption of a policy, and pressuring supervisors to include innocent people in the TSDB, this would not happen. And let me tell you, it's all about the money, because federal money is allotted with these projects, is allotted to these projects. So the more people they put in there, the more money they get to monitor them, right? So basically, they're just trafficking with innocent people that are not terrorists and just putting them on the list only to get more money for the agency.
It's extremely upsetting. The next argument is about cause of action available to plaintiffs. The defendants ignored all the pleadings that are related to the Fourth and Fifth and Eighth Amendment claims, and instead they obsessively reducing plaintiffs' claims to V2K and microwave attacks. That's all they want to talk about. However, nowhere in the complaint, plaintiffs allege that V2K and microwave attacks are conducted by the defendants. Yet, that's what defendants are talking about, while we are talking about the violation of the Fourth, Fifth, and Eighth Amendments. So it's like a broken telephone. We're not answering each other's questions.
That's exactly it. You see, the complaints first 53 pages are entirely about the scheme by the FBI of placing innocent people into the list, of doing assessments, which we'll talk about a little later, which are the illegal surveillance of American citizens without warrants or with defective warrants, without an Article 3 court warrant. All the hacking, all the surveillance they do of all electronic communications, and also the breakings to the houses. That's in violation. All of this in violation of the Fourth Amendment. Also the psychological operations and the putting the people on the list without due process, which is a violation of the Fifth Amendment, and the cruel and unusual punishment that constitutes the PSYOPs carried out by the fusion centers that do implement the policies by Mayorkas and Weinstein. So there's a lot of claims that do fall within the Bivens context, right? But no, they're trying to insist on talking about the things that plaintiffs never alleged that defendants were perpetrating, which is the microwave attacks and the V2K. But the reason they do that is because they want to continue with the narrative that it's fantastical and it's a conspiracy theory. But the first 53 pages are based on admissions of fact. First, You have Timothy Grow admitting innocent people that don't have meet the reasonable suspicion criteria are placed on the TSDB. That is admitted under penalty of perjury. We have an admission by Christopher Wray of the 200,000 assessments done on American citizens under, I don't know if it's using the FISA court mechanisms, and the allegations regarding the break-ins to the houses, the allegations regarding the psychological operation of the fusion centers. They are very well. We added this Brennan Center for Justice report on the abuses to people's civil rights carried out by the fusion centers. That's one of the exhibits in the complaint. So there's a lot of uncontroverted information in support of those 53 pages that are the basis for the complaint. In fact, if we didn't mention the program, only with those first 53 pages, that's a sufficient complaint against these defendants. So they want to place something to cover the eyes of the judges so that they don't see the truth. But the court, this particularly the Court of Appeals, the Supreme Court has said this: when a case has been dismissed on a motion to dismiss basis, as is this one, the Court of Appeals has to take as true the facts of a complaint. And defendants don't want the Court of Appeals to do this, obviously.
Let me ask you a hypothetical question. If we did not even mention microwave attacks and did not mention V2K and said there are other effects that we would disclose later in the discovery, would that change the game? Would that change their strategy?
They would not be able to allege. That's why they are clinging on to the narrative of the fantastical, because that's the only thing they can claim as fantastical, because the other allegations have been admitted by defendants publicly. They are in newspaper articles. They are in statements under penalty of perjury. They are contained in Office of the Inspector General audit reports of the Terrorist Screening Center or United States Department of Justice audit reports. So they are what we call in the legal field uncontroverted material facts. That's why they have to cling on to the fantastical allegations, because the other is so solid and it has been admitted by them.
But when they make a claim that V2K is fantastical and microwave attacks are fantastical, that also contradicts current level of knowledge. It might be unknown to a judge, but the judge can be educated. So why wouldn't the district court judge take the time, read our complaint, and educate herself about this?
Well, that's what this morning I was just thinking that the attorneys for the man in Ohio that killed his neighbor, it was 4 neighbors, a mom and her daughter and a 2 elderly couple. His attorneys should really knock on targeted justice door and ask for help proving what V2K is and what it does to a person, because as part of their defense, they definitely should use this, because we have to start educating courts that it's not only patented technology, but it's being used and abused by the United States government to torture its own citizens. And as horrible as that is, because, I love America. I am an American citizen and I love this country. And it's horrible to think that our own government is doing this to us, but it has to come out in the open, just like MK Ultra did in the 1970s with a church committee. It has to come out in the open.
I cannot forget the question that John Kiriakou asked Bill Binney in the most recent interview. He said, I am a CIA whistleblower, and do you really think that the government would do something like this to our own citizens? And I was thinking, John, you're the CIA, you blew a whistle on the CIA torture program, and you are having a hard time believing that the government would do it to its own citizen. Once you cross the line, once you do it to anybody, then everything is permitted. That was the moment that really gave me a long, long pause about how naive people could be. Yeah.
In this juncture, I just have to take advantage of what you just said, because I want people to know how criminal these people are. Just this week, one of our plaintiffs, she's a young 40-year-old. The criminals that torture through V2K used her mother's voice to broadcast to this little 4-year-old to take her little fish, put it in a cup, put boiling water in it from the dispenser, and put soap in it. And they all did it using his mother's voice on her pet fish. This is how these criminals work. They have no respect for anything human. And we have to end this program. But as I have insisted, and I insisted before the Court of Appeals, plaintiffs have not alleged that it is these defendants that are doing it. And that is one of the intentional deceptions that defendants are representing to the court. They are saying, first of all plaintiffs, and you and I know that not all plaintiffs have B2K. And second of all plaintiffs allege that defendants are broadcasting messages to them. And that is a false statement of fact. If you verify the complaint, nowhere does it say that defendants broadcast messages to plaintiffs. Nowhere.
That is correct. This is a claim about the dismissing Privacy Act claims. So defendants argue that plaintiffs had to exhaust administrative remedies, which is incorrect. That the defendants consistently refused information and denied all similar privacy claims. And finally, by neglecting to address the discussion of the FBI's unauthorized dissemination of false information labeling individuals as suspected terrorists, defendants waived any objections to it.
You have to remember that the Privacy Act claims were two. One, that they refused to answer the information on the TSDB status of the Privacy Act claims that were sent. They're like, oh, we do not confirm or deny, right? That we don't have to exhaust, my plaintiffs don't have to exhaust the remedies, because the courts have said when it's an exercise in futility, you don't have to, because we're not going to force you to waste your time. That's one. And the number two is that they don't even discuss the Privacy Act violation of spreading misinformation, false defamatory information about plaintiffs, calling them suspected terrorists. That they are like, oh, it's not there. They, like it's not part of a complaint, and it's one of the claims. So they completely disregard it because there's no way to defend that it's okay to label a non-terrorist as a suspected terrorist.
Beautifully said. 1, 2, 3. Very clear. Denial of the preliminary injunction. I think this is one of the final arguments that you make. We asked for a preliminary injunction to take our names off the TSDB because we're all suffering, we're all tortured, there are real consequences for real people. And defendants said plaintiffs have no likelihood of success on the merits. The government's interest in combating terrorism justified that denial. Defendants also failed to provide a single document proving that the elimination of the names of people that do not represent a terrorist threat from the TSDB will result in any government harm. That's really important. And finally, defendants' refusal to produce the limited discovery on the 18 plaintiffs almost creates a presumption that they are on the TSDB, because if they produce the info and none of the plaintiffs were on the TSDB, the case would have been over.
That's exactly right. Let me clarify that we asked for the preliminary injunction I think it was February 25, a little over a month after we filed a lawsuit. And the reason for that is because, as you very well know, everybody's targeting multiplied. It was, increased substantially. So I filed a preliminary injunction to the court saying, look, there's irreparable harm happening here. As you may recall, it was so much so that the daughter of one of our plaintiffs started to be targeted. She wasn't targeted before, and they started targeting, and that's why we amended the complaint to include her. So we're saying, court, this is really urgent. So when a court does a balancing, the court has to do a balancing act between what the plaintiffs are asking for, which was the removal of the names of these 17 plaintiffs from the TSEB, vis-a-vis the argument from the government, the potential harm. We say, well, they didn't prove any potential harm, because what harm can you suffer from eliminating the names of non-terrorists from a terrorist list? Nothing, because Timothy Grow admitted they represent no threat to national security. So the government couldn't argue, seriously argue that they would sustain any harm. Now, we also asked for a permanent injunction in the main lawsuit, which is a permanent injunction for a national injunction to remove the names of all non-investigative subjects from the TSDB. And that includes all of targeted justice members, and that includes all of non-targeted justice affiliated people, simply all the innocent non-terrorists on the list. We asked that in the complaint as a permanent injunction. So that's another remedy that the court does not discuss, and that the court had to carry out also the balancing act, because it's supposed to be a balancing act, except that in this case, there's no balancing act to be made, because there is no way to justify the inclusion of innocent people on a terrorist database.
It's like an argument chasing its own tail, and it never stops. This is the situation we're in. And finally, you finish your brief with a powerful conclusion that the public interest justifies forcing public officials to comply with the law. What could be more controversial? The public interest compels the elimination from TSDB the names of plaintiffs, targeted justice members, and unsuspected innocent Americans illegally labeled as suspected terrorists. The public interest compels the elimination of TSDB categories that comprise McCarthy blacklist. Not what the defendants say, that we want to eliminate TSDB. That is not what we're asking. We're asking elimination of TSDB categories that comprise this McCarthy blacklist. And the public interest supports the reversal of the district court's decision. The remand of the district court and the ordering of the immediate production of complete, unredacted TSDB, and none of that data set business.
That's exactly right. Well, this public interest phrase I got from, that's one of the arguments. They say the public interest compels the court to not mess with the TSDB. And I'm like, no, you're wrong. The public interest compels that they comply with the law, that they respect people's civil rights and privacy rights and constitutional rights, And as was argued, one of the most important things is that their intentional deception of blocking access to the information is almost an admission of fact that plaintiffs are on the TSDB. Because if they didn't oppose it so staunchly, the case would be over. If they're not there, if Len Bear's name is not in the TSDB, the dismissal, you know what? I would have to file a motion for dismissal, for voluntary dismissal of Len Bear's claims, because I cannot support my contentions. And so in this situation, the public interest compels transparency, and that innocent people are not falsely labeled as suspected terrorists. And as we like to talk about, at the synchronicity, I think we are living in a historic moment where they have gone overboard putting innocent people like James O'Keefe, very well-known people, on the terrorist database. And now it's gonna backlash at them, because people are realizing this is all fake. Normal people are realizing it's the TSCB is a weapon to punish anyone that has a narrative different from the government, among other things. It's just a tool to punish people, and that's not what it was supposed to be.
And I want to finish with that powerful sentence that you put in the beginning of the brief. The arguments of the defendants are based on deceit. If that doesn't impress you, I'm sorry, you need a reality check, because let's call a spade a spade. The government strategy, the defendant strategy, is based on deceit. That's the most powerful message. From the very beginning of our case, from January 2023, it took us all this way to finally call their strategy deceit. And I thank you for that moment of honesty, Anna.
Well, you're very welcome, but please remember that in my replies to the motion to dismiss, I listed the false and misleading statements by the defendants written in their motions. So, you have to always do it with respect, but it takes guts to do that, because not many people are willing to call a spade. And that's exactly what we've been doing since day one.
Yes, but I just feel that all our efforts came together and we're finally speaking about it openly. There's nowhere to hide. There's no fences to build. We are at the moment of honesty when we say their strategy is based on deceit. In our second segment, we'll show you a couple of clips that Anna sent me, also relevant to the topic we discussed in our legal segment. Anna sends stuff from her desk. I don't know how many desks you have. You have a legal desk, and then you have a media desk. When you send things from your media desk, my ears perk up, because these stories are remarkable. The first story is from House Judiciary GOP. Let's get this straight. DOJ's U.S. Assistant Attorney General for the Civil Rights Division, Kristen Clark, is not familiar with Missouri v. Biden, one of the most massive attacks on free speech in American history, and the largest Supreme Court case this year. Wow. Let me give you some facts about this case. It was filed in the Western District of Louisiana on May 22nd of last year. Among defendants, Joe Biden, our president, Vivek Murthy, I think it's a Surgeon General, Javier Becerra is the Secretary of Department of
Health and Human Services.
Health and Human Services, thank you. And Anthony Fauci, he was a medical advisor to the president. The case went to district court. District court issued order in favor of plaintiffs, and then it went to U.S. Court of Appeals for the Fifth Circuit. This is our court. And it reaffirmed district court decision on October 3rd, 2023.
Let me butt in here. And this case has been famous because this is also associated to Matt Taibbi's Twitter files. And it's associated to the fact that the FBI had a little field office over in Twitter, and they were doing surveillance, monitoring, and shadow banning of Twitter users. And these were not influencers. These were not people with huge accounts. These were people with 1,000, 2,000 followers, okay? And the district court, they got all the evidence that the FBI was carrying out an impermissible infringement of the First Amendment rights of people. And that's what the Fifth Circuit confirmed. So it was a huge case. This is being a huge scandal. Everybody knows about Missouri versus Biden, and everybody is biting their nails, waiting to see what the Supreme Court is going to decide, if they're going to confirm the Fifth Circuit and what their expressions are going to be, because it's the huge governmental interference with the First Amendment. And so that's why, even my son knows about this case, and he's not an attorney, and he's young, he's not into these things. Everybody knows about Missouri versus Biden.
But let's see the clip and let's be amazed.
Missouri versus Biden case in the district court, the court explained, quote, if the allegations made by the plaintiffs are true, the present case arguably involves the most massive attack on free speech in United States history, close quote. Court went on to find that the plaintiffs were reasonably likely to succeed on the merits at trial, entered a preliminary injunction. The Fifth Circuit has affirmed. The Supreme Court has taken jurisdiction of the case. Of course, that's all civil litigation. Is any criminal investigation or prosecution of the persons responsible for that activity in the FBI, CISA, and at the White House and their co-conspirators underway in the Civil Rights Division?
Congressman, I'm not familiar with this litigation, but happy to bring your question back.
Thank you. So let me just make sure I understand that. You are not aware of the Missouri versus Biden litigation that is currently being taken up by the United States Supreme Court. Is that correct?
Unfortunately, I'm not, Congressman.
Oh, assuming not, assuming that you're not aware of that, what reason would there be that the Civil Rights Division of the Justice Department's leader is unaware of what a United States District Court has described as the most massive attack on free speech in the United States history?
If you could share more of the facts, that could be helpful, Congressman.
Otherwise, you just don't know. Is that correct?
That's correct. Unfortunately, this does not appear to be a case that I'm familiar with.
That is a wow, don't you think? It's incredible. It's incredible to watch. I think this case made a lot of people in the government uncomfortable.
First of all, no reasonable person can believe that woman, because the Missouri versus Biden case it's the most important case in the Supreme Court right now. Okay. And President Biden was sued. If she doesn't know about it, she's plain incompetent and should be fired, because she's an assistant attorney general. She should know every single word of the case by heart, because she had to be in the meetings planning the strategy and the defense of that case. That is the single most important case of this administration right now. And also TJ versus Garland. But
Yes.
Given the fact that it's in the Supreme Court, she should. And it's like, I love, there's a case in Puerto Rico that the Supreme Court said witnesses should not pretend that a judge believes what a normal person wouldn't believe. So if a normal person that wouldn't believe it, don't ask me to believe it. Right. And that's exactly what I can have to say about this woman.
If we asked her, is she aware about targeted justice v. Garland? I can't even imagine what she would say, but I'm sure she wouldn't know.
Let me just say something with her, though. Yes. What he asked is very important. What have you done to punish the civil rights violations carried out by those FBI agents that the court already adjudicated, because the court received evidence that they were intentionally interfering with people's free speech? So she prefers not to answer by saying, oh, I don't know anything about that case, because they haven't done anything to all those FBI agents that interfered and violated those persons' civil rights. So that would be another admission of guilt. The admission of guilt because remember one thing, the FBI is under the purview of the US DOJ. So all those violations by the FBI are also attributable to the DOJ that is supposed to advocate and watch for the civil rights of every American.
Let's move on. American News reports on the same day, December 5th. Mike Lee blasts FBI Director Chris Wray over warrantless surveillance of Americans. It's why we have a constitution, sir, and you must comply with it. Some facts about this clip to make sure that everybody knows who we are talking about. Mike Lee is a United States Senator from Utah. He's a Republican, has been there since 2011. He's a lawyer by profession. Christopher Wray is a director of the FBI since 2017. He is a Trump nominee who replaced James Comey. Section 702, which they will be talking about, is a key provision of the FISA Amendment Act of 2008 that permits the government to conduct targeted surveillance of foreign persons located outside the United States. FISA stands for Foreign Intelligence Surveillance Act. And in the regulation, it says who cannot be targeted under Section 702. U.S. persons, regardless of location, and any person located inside the U.S. And there's another category, but these are two main categories. So that sets up a stage for our next clip. Let's watch it.
FBI and other agencies searched Americans' communications over 200,000 times, only 16 of which were evidence of a crime-only searches that returned information. I'd like to ask you to give a yes or a no answer to these questions. Were the three related batch queries consisting of over 23,000 separate queries relating to the events of January 6th, were those evidence of a crime-only queries, yes or no?
I don't know the answer to that.
The
What
answer
I
is-
can't, what,
The answer is no. I
what I-
do know the answer. The answer is no. Were the
What I-
141 queries for the activists arrested in connection with the George Floyd protests here in Washington, D.C., evidence of a crime-only queries?
those were non-compliant queries. And again, they all predate the reforms that we've put in place, which before we,
echo other reforms that other FBI directors
Which
have told me about
took-
every darn year.
if
How
I
about the
may.
19,000 donors to a political campaign? The answer there is no. What about the query for a sitting member of Congress? The answer there is no. What about the query involving a U.S. Senator, which for all we know could be any one of us? The answer is no. And so what does that tell me? Well, what I'm hearing and what these data points all point to is that a warrant requirement or prohibition relating to quote unquote evidence of a crime only queries would not have been something that would have prevented any of the most egregious examples of the abuse that we've seen under Section 702. So the FBI is already required to obtain a court order in some circumstances before accessing the contents of Americans' communications in the context of 702. They're already required for that in some circumstances. Since 2018, how many times has that requirement been triggered according to government reporting? Do you know?
you talk about the so-called F2?
Yes.
Yeah. How many times has it been triggered?
Yes.
I think there've been 2 instances where I think is maybe the number.
103 times it's
Yeah.
been triggered. And out of those 103 identified times, the FBI should have obtained a court order. How many times did the FBI actually obtain one? Do you know?
That I think the answer is none.
0. So you're telling me that the FBI has completely ignored the limited court order requirement that it's already subjected to. You have the audacity to come here and you told us that adding a warrant requirement to 702, even for queries involving U.S. persons on U.S. soil, that would amount to some sort of unilateral disarmament. That you have a lot of gall, sir. This is disgraceful. The Fourth Amendment requires more than that, and you know it. I know every single time for centuries, even prior to the founding of this country, there were similar protections built into the laws of the United Kingdom before we became a country. Even then, the government was making the same darn argument you're making today, which is it's too hard. This would make it hard for the government. It's why we have a constitution, sir, and you must comply with it.
Mr. Chairman, may I respond briefly? When you ask why are things different this time, I would point you again to the findings of the court and the department themselves, both of which have not been shy about identifying some of the same instances that you cited in our colloquy. They themselves have observed the effectiveness of the reform, which is why the pre versus post date of the reforms becomes very significant. So that's number one. Second, as to your claims about constitutionality, I would point you back to what the case law actually shows on this subject, which is that no court has found 702 in its current form to be unconstitutional, and every court to have looked at it has found it to be constitutional.
Well,
and last point,
How lucky for
last
you,
point.
because no one has standing to do that. No one knows when they're being surveilled. That is not an argument, sir.
Last point, Mr. Chairman, is that in some of the instances, and you went through a number in your questions, in some of the instances in particular that I know about, those are instances where the queries were run in order to get to a public official, member of Congress, to warn them about foreign influences targeting
Yes,
them. And a
we call
warrant
those
would not have enabled that.
We call those consent searches. And consent searches do not require a warrant, sir. And you know that. There is nothing that you have done that is not entirely within the FBI's control and supervision. You're asking me to believe something that is not believable because your agency has made it unbelievable. And I refuse to accept it.
That
What an elegant way to call someone a liar. You're asking me to believe something that is unbelievable. I have to write that one down because it's just so elegant of him, you know. And that's what we attorneys have to do. We have to, you know, sort of beat around the bush sometimes. But let me comment that 200,000 number of the assessment on Americans, that is specifically alleged in our amended complaint, because those 200,000 assessments are on targeted individuals. And that's what we have alleged from day one. That's one of the illegal Fourth Amendment violations that the FBI incurs in, and that Christopher Wray and that Mr. Cable engaged in against innocent Americans falsely labeled as suspected terrorists. And the second thing is, he said it brilliantly. He says, oh, it's constitutionality being upheld because the victims of it, no person is ever informed that a FISA warrant was obtained against them, so they never get the opportunity to challenge it in court. That's why, like he said it brilliantly, no one has standing to bring a challenge. So, I mean, that out of all the quotes, because I know this week it was a rough week for Mr. Wray in the Congress, but of all the ones I've seen, this one, as it pertains to targeted individuals, is the most on point, because this is what we have alleged. But for Section 702 of the FISA Act, they would not have been able to do a lot of the violations. But for this, these are the criminals. But for 702, FBI, Mr. Wray and Mr. Cable would not have been able to perpetrate a lot of the surveillance and Fourth Amendment abuses on TIs, on targeted individuals, on plaintiffs, on targeted justice members.
Yes, this is very, very, very clear. You're not supposed to know, and we're not going to let you to find out, and therefore there could not be any claims about this. They built this fence around it, and we asked the judges to remove it because it is unconstitutional. That's our show today. We looked at the legal brief. We looked at a couple of clips. I hope we kept your attention. And now, Anna, please, your final words.
Well, I am, sometimes one gets down, one gets up in terms of when things happen, in terms of the case. But I am so very convinced that the court will understand our plea and will side with us, because it is time for freedom. It is time for innocent Americans that have been unjustly and illegally placed on this list to be set free. So we privately, you and I talked, this case was never supposed to reach such an important forum as the Court of Appeals, because I have read over 200 cases that have been dismissed as crazy, fantastical, and they're not even published. But this case was never supposed to reach such an important jurisdiction. And I am confident that the truth is, the truth and the justice are around the corner. So to all of you out there, just stay strong. It is also hard for me. It is very hard for Len too. But we're staying strong because we are envisioning a world where we're all free. And that's going to happen soon. I am absolutely certain it's going to happen soon.
I'm with you, Anna. I dream about that moment when we are free. We don't have any interruptions with our life, whether it's V2K, remote neural monitoring, stalking. It has to be eliminated completely, entirely. And as to me, I'm naming this episode, Let's Call a Spade a Spade. You can tell how excited I was about that sentence that Anna used in her reply brief. It really struck a nerve with me. The arguments of the defendants are based on deceit. This is what Anna wrote. And I want to make sure that what I will say now is not a reflection on her position or the position of targeted justice. These are my Len Bear's words. Deceit, deception, duplicity, fraudulence, chicanery, crookedness, sham. These are all words that's synonymous with deceit that Anna, due to her professionalism, would not use. So allow me, a plaintiff in this case, exercise my First Amendment right and use them interchangeably. I wish that today's podcast will reach the ears of more than just the targeted individuals. It must reach the ears of journalists, politicians, law enforcement, military contractors who are knowingly or unknowingly involved in the fate of targeted individuals. And most importantly, the ears of the judges in the Fifth Circuit, who recently confirmed the district court decision in Missouri versus Biden, who pride themselves on upholding the Constitution of the United States of America and the Declaration of Independence and the rights endowed to us by our Creator and not by the FBI or the DOJ, who abandoned their oath to protect our God-given rights and sold American law-abiding citizens 40 shekels a soul, until everybody in this country and around the world know what these agencies are doing under the color of law. We will be here every Sunday, rain or shine.